Good afternoon, and welcome to the William G. McGowan Theater that's located here at the National Archives in Washington, D.C. And I also would like to extend a special welcome to those of you watching online on our YouTube channel. My name is Maria Marable Bunch, and I am the Director of Education and Public Programs here at the National Archives. Before we get started on today's program, a lecture that's being presented by Geoff Shepard based on his recent book, The Real Watergate Scandal. I would like to share with you some upcoming book lectures that we have planned at some future dates. Actually, tomorrow at noon, we're expecting the historian Jay Winnick will be here to discuss his book, 1944, FDR and the Year That Changed History. And on Thursday, October 29th, we're expecting Kevin Lippard, who will be here to discuss his book, War Plan Red, United States' Secret Plan to Invade Canada, and Canada's Secret Plan to Invade the United States. Both of these events will be followed by book signings that will take place after the program. To find out more about these and all of our public programs, please consult our monthly calendar events that are located in the theater lobby, or you can visit us on www.archives.gov. That is our website. Our today's speaker, Mr. Geoff Shepard, he holds a degree from Whittier College and the Harvard Law School. He was selected as a White House Fellow in 1969 and assigned to the Treasury Department, where he worked under Paul Volcker, then Undersecretary for Monetary Affairs. Following his fellowship years, Mr. Shepard joined John Ehrlichman, domestic counsel staff at the Nixon White House, where he served for 5 years, first as a staff assistant and ultimately as associate director. After today's lecture by Mr. Shepard, there will be a book signing of his book that he's going to share with you today for book signing that you will find just outside our National Archives bookstore. So in a way, let's welcome Mr. Shepard.
Thank you. It's good to be here with you and talk about my book. My book is a very threatening book. It's threatening to the people who were victorious in the Watergate scandal because it documents judicial and prosecutorial wrongdoing. And we'll get into that during the course of today's discussion. But it's also a love story. The subplot of my book is a love story between me and the National Archives, because the National Archives has all the records that helped with the documentation of my book. This is my first book presentation here, but this is not the first time that I've spoken at McGowan Theater. I've been here 10 times before. Let me tell you how that happened. As Maria said, I graduated from Harvard Law School, and upon graduation was selected to be a White House Fellow. And then after my fellowship here, I joined John Ehrlichman's domestic counsel at the White House. So at the ripe age of 24, I became the youngest lawyer on President Nixon's White House staff. And I stayed 5 years on the domestic counsel. It's the counterpart of the National Security Council, and it staffs the president on domestic initiatives, just like the NSC staffs him on foreign initiatives. And my focus was the Department of Justice. So I knew everybody involved in Watergate. I'd worked with them. Some I liked, some I didn't like, but they weren't names in a newspaper. These were people that were known to me. And then, as the tide of Watergate rose, I demanded a seat at the defense table. And I became principal deputy to Fred Bizart, who was the president's principal Watergate defense lawyer. I don't want you to think that I was in charge. I joined and left the White House in my 20s. But I was in the room when the decisions were made. And most of the other people who knew what was going on the inside have passed away, and here I am. And I would submit I know more about what went on inside the Nixon White House with regard to Watergate, to the end game of Watergate, than anyone else who's still alive. I did one other thing, though, after leaving the White House. I've run the reunion group for the Nixon White House staff for the past 40 years. And these are not the campaigners, these are the policymakers, the staff of the NSC, the Domestic Council, and presidential appointees to OMB. We meet every November after the election, and we talk over government issues and challenges, particularly from a Republican point of view. Then, starting in 2010, 5 years ago, I started producing what are called Nixon Legacy Forums. And what you would do is get 4 or 5 of these people who worked on a particular initiative and get them to reminisce about what they were trying to do and whether they accomplished it and what the documents show. And we co-sponsor these with the National Archives because, as David Ferriero, the archivist, says, these people make the documents come alive. So over the past 5 years, we've produced 35 Nixon Legacy Forums, 10 of which were done here in McGowan Theater. The other thing that I do, because I'm a sore loser, is I spend an awful lot of time researching Watergate documents. About 12 years ago, I made a very happy discovery, and that was that the National Archives had the documents. I mean, what is so intriguing is that the special prosecutors were government employees. So all of their documents should have ended up at National Archives, and most of them did, and we'll get into that too. But I have spent an awful lot of time researching these documents, and the documents form the basis of the book. You may not know this, but in general, in the great scheme of things, White House documents are out at each of the presidential libraries. So for President Nixon, those are out in Yorba Linda, 42 million pages of documents. Here at Archives 1, on the Mall, they not only have the Constitution and the Declaration of Independence, the Bill of Rights, but they tend to have all the legislative and court documents. So you come here and you can see the briefs that the people in the Watergate cover-up trial filed in their effort to achieve due process. And then out at a building called Archives 2 out in College Park, Maryland, they have all the rest of the executive branch documents, not the White House, but everything else. And they have one unit out there called the Special Access Section. And the Special Access Section contains the documents from the Kennedy assassination, the Nixon Watergate documents, the President Clinton impeachment. And those are kept in a special unit, and you can't just go traipsing through them because you'd like to. Because they're investigatory documents, archivists have to read and redact the names of the innocent before they'll let you see the documents. So it's a hassle. You do it with FOIA requests, and it takes a while to get the request because they have to go review the documents before you get to see them. And I've made a general pest out of myself over 12 years, and I have lots of FOIA requests filed. And it's something like what's called a closed stack research library. Suppose you have a library about a bunch of biotech documents. They won't let you go look through the stacks and pick off any book you want. You have to work out of the card catalog, if there is today a card catalog. It's the same thing with the special access section. You request what you'd like, and then they go decide what's responsive to your request. So you're never quite sure that you're asking the right way or that you're getting the documents. So you keep going back again and again, and that takes a while. So based on my view, the real Watergate scandal turns out to be the trashing of our Constitution and Bill of Rights in the successful effort to drive Nixon from office, to imprison his senior aides, and to realign political power without the inconvenience of an election. If you were around at the time, you remember the mantra was that no man is above the law. And it's true. We are a nation of laws and not men. No man is above the law. But these people were the law. the people who were called upon and given the extraordinary powers to investigate and prosecute and preside over the Watergate trials. And it turns out to be the same age-old question that we've struggled with since time immemorial. Who will protect us from our protectors? Because these people were given extraordinary authority, and then in my view, it went to their head and they abused the authority to correct political items that they wanted to change. And what's so unique is it may have started, or in my view, come to the surface in Watergate, but it's going on today, just today. The lead editorial in the Wall Street Journal bemoans the Wisconsin's John Doe investigations of Governor Scott Walker. And the news in the editorial is that they have discovered that during this secret investigation of funding for conservative support of Scott Walker, the investigators, Democratic investigators, did not limit themselves to people in Wisconsin. They were targeting nationally prominent conservatives. And the record shows that. And it is, in my humble view, the same exact situation that you get with Watergate. Now, our founding fathers had experienced a concentration of power and abuse, and they developed this Constitution, which is copies of which are downstairs, which is as revolutionary today as it was hundreds of years ago. It divided power, governmental power, between three co-equal branches. And then, because they didn't even trust that, it set up a Bill of Rights, which guarantees individual rights vis-a-vis the government. And as we go through this, I think you'll notice that what I believe happened is all of that was swept aside in the political eagerness to get back at Richard Nixon. So with that, we start through. So what is the thesis of my book? Well, the thesis is much of what you've been told about Watergate turns out to be untrue. President Nixon was driven from office largely by false representations of highly partisan Democratic prosecutors. His aides were denied any semblance of a fair trial. In brief, the fix was in, the dice were loaded, the deck was stacked. And we'll go through each of those as we get into it. Why now? Why 40 years later do I stand before you and talk about my book that came out 2 months ago? And the answer is that the three top prosecutors took their records with them. Now, they're not supposed to do that. These are government documents. That's understood from the outset. And it's kind of a cover-up because these were the most sensitive documents, and they took them. And at least what turned out to be among the most sensitive were taken by Leon Jaworski, the second special prosecutor. He took them back to Texas when he left. He had a legal career, died, gave his documents to his alma mater. That's a lesson you should learn. Your documents go to your non-governmental documents go to your alma mater. Baylor took its sweet time making them available to the public. And then somebody was down there looking at them and said, well, these are grand jury transcripts. These shouldn't be out. Archives was notified. They went down, they looked, Baylor cooperated, and the files came back. I had one of my innumerable FOIA requests pending, and I was among the very first to see these newly uncovered documents. And I photocopied, photographed, scanned, and took my set home. And then I start reading through them, and I discover just incredible stuff that forms the basis of the book. Two other of the special prosecutors, Archibald Cox and his top assistant, James Vorenberg, took their documents back to the Harvard Law School. And they still sit there. And I pointed out to archives this summer that there is, in one instance, in Cox's file, the original grand jury transcript of a significant event that is just sitting up there in Cox's files. And what happened in James Vorenberg's files, he was Cox's top assistant, and he appointed himself very early on the responsibility of writing the report when it was all over. So from day one, he's keeping a chronology in his own handwriting in a notebook of what's happening and when. And he took it with him. And then he had a full career, became dean of the Harvard Law School. He passed away in the year 2000. It took them at least a dozen years to get around to organizing and opening his files. And I believe I was among the very first this past summer to go look at his files. And they're just shocking. They're not in my book, but they're just shocking because if you know what you're looking for, it gets confirmed time and time again in Professor Vorenberg's notes. And those shouldn't be there. Those should be down at archives. I was enthusing with a former attorney general earlier this summer about my find. And he said, what makes you think those records are going to be there when you go back? And I thought about that. I said, well, I've scanned my set. You know, I got my set. But I went back and looked, because you can, they're not in date order. They're all confused, because people have, not people, but Vorenberg and others went through it before it was given to the library. And you arrange it by date, and there's 4 months missing. I mean, he does it every 2 weeks of what happened the 2 weeks before, but there's a 4-month gap. And that's why archives ought to have these records, and they ought to be available now and in the future to future researchers. So, just to remind you of the players, in case you weren't around for the unpleasantness, the folks across the bottom are the ones who did the deed. They're the real criminals. They got their hands dirty. So Gordon Liddy orchestrated the break-in. Jeb Magruder was his boss. He sent them in, and he lied to grand juries about it in the cover-up. And John Dean ran the cover-up. In his own admission, he was chief desk officer of the cover-up. The three people across the top are Nixon's top aides. John Mitchell was Attorney General and then head of the Re-election Committee. Bob Haldeman was his chief of staff. And John Ehrlichman, my boss, was head of domestic affairs. But he'd been counsel to the president before that. And the issue then and today is whether the folks at the top were orchestrating the cover-up by the folks at the bottom. And it's not a situation where we're talking about innocence or exoneration. Those words don't come up in a scandal like Watergate. The question is, because these three were sent to jail, the question is, was the case made in a court of law before a jury of their peers beyond a reasonable doubt that they were orchestrating the cover-up? And that's the issue, and that's the issue that I explore in my book. I don't think the case was made, and I think because the case was rather flimsy, they'd been blamed in the paper, they'd been tried and convicted before the Irvin Committee legislative trial, but the case couldn't be made in court, so the judges and the prosecutors cheated. They cheated to secure the convictions, and that's what the book is about. How did we get to this? Well, these are the pictures of the Attorney General and his professor. On your left is Elliot Richardson. Elliot Richardson was brought in to be Attorney General after the collapse of the cover-up because he was clean. He just wasn't involved at all. But he didn't want to be Attorney General. He'd just been confirmed as Secretary of Defense, and he was very happy there. As it turns out, he harbored his own ambitions of someday becoming president. And he didn't want to be involved in Watergate because to make the tough choices in Watergate was to upset one side or the other and be enmeshed in this controversy. So he wanted nothing to do with it. I call him the Pontius Pilate of Watergate because he washed his hands of it and removed the entire Department of Justice from the fray. And what he did to do that was rather happily delegate all of the prosecution authority to his former professor, Archibald Cox. Archibald Cox was an intriguing choice to be special prosecutor. He was the Triple Crown winner of the Kennedy political dynasty. He had worked with Jack Kennedy since 1953. He traveled on the campaign plane with the candidate in 1960 when candidate Kennedy was running for office. He assembled and led the academic brain trust for Kennedy during the campaign. His reward for being a loyal and partisan advocate was that he was appointed Solicitor General of the Department of Justice when Robert Kennedy was Attorney General. He was a great Solicitor General, but he was highly partisan. He swum with the sharks. And then after he went back to Harvard, he became the principal staffer for Senator Ted Kennedy in his opposition to President Nixon's Supreme Court appointments. So if you go through the records, you get this exchange of letters where he's explaining to Senator Kennedy how to go about opposing individually and in turn the people that President Nixon nominated for the Supreme Court. An interesting choice to lead the investigation. He then decided to appoint his friends to assemble the special prosecutor's office, and he brought first 2 professors with him from Harvard Law School, and they appointed people they knew, people they had worked with. That way they didn't have time for FBI investigations, so they appointed people that they already knew. And you ended up with somewhat of a biased selection doing the investigation. The bias was they all hated Richard Nixon and the Republican administration. This next slide, and when I lecture at law schools, I tell them this is going to be on the exam, and I know you can't read the names, but you can see the colors. And this is the Kennedy-Johnson Department of Justice, the previous administration to President Nixon's, and the names in red, and there are 17 of them, all ended up on the special prosecutor's staff. So the entire leadership and the top 17 most senior members of the special prosecution force had all worked together in the previous administration. These are the people who were thrown out of office by President Nixon's 1968 election, and they had total and unreviewed authority to investigate the Nixon administration. And the Nixon administration had no authority to investigate any Democrats because Elliot Richardson thoughtfully gave that to Archibald Cox too. The fact that they didn't investigate prevented us from saying, well, you know, we're not alone. Look at what these other people did. So we were the only ones being investigated by people who didn't like us. Now, the next slide, and I know you can't see these faces, but they'll be on the exam too. This is the prosecution staff on the courthouse steps. There's 100 people there. They're not all lawyers. If you count turnover, there were about 60 lawyers on the special prosecutor's staff. But this doesn't count the FBI and the IRS agents they could direct in their investigation. And what they announced at their first press conference was they would investigate not just Watergate, but every single allegation made against the Nixon administration since it took office. And they set up task forces and they decided who they were going to go after. And the result is what we call the Watergate scandal. No institution, no business, no charity, not your church, could withstand a determined investigation by 100 people who didn't like you with all the time and budget they had to go after people. In its own way, this is a criminal bill of attainder. We know who we don't like. We're just going to go find what we can charge them with. So we scream bloody murder. Ron Ziegler, the president's press secretary, said this is a bunch of zealots. They're out to get us. Don't believe what they're telling you, what they're leaking to you. And what the special prosecution staff did was decide to write a public letter to Ziegler saying, you know, you got to quit complaining about this. We're objective. We're just enforcing the law, and we're doing this in a proper manner. And I'm going to read you the key paragraph in this public letter. This is from Leon Jaworski. When I first assumed the task, I'd been forewarned, based on rumor to be sure, that there were those in the special prosecutor's office who were zealots, determined to achieve their own end regardless of truth. I'm now prepared to assure you, after a month of close association with the staff, this suspicion is totally unfounded. I've worked daily with my principal subordinates, reviewing data being assembled, additional sources to explore, recommendations to consider, and action to be taken. In my experience at the bar, I've found no group who as a whole are more objective, more fair-minded, more dedicated to a search for truth than this unusual group of talented lawyers. If I find any among them who do not meet the qualifications of fairness and objectivity, I would not hesitate to dismiss them. Now, this we call a ringing endorsement of his staff. Jaworski had been there a month. he didn't draft this letter. It was drafted for him by the staff. And they said, look, are you with us or are you not with us? We're under attack, and here's what we want you to say. And he signed the letter, and the press jumped on it, and we were told, you know, Ziegler's wrong. These are objective people. So we ask ourselves, what did Leon really think? And one of the records recovered from what he took to Baylor that came back, and I looked at, is an exchange of memos between Leon Jaworski and his deputy, Hank Ruth. Hank wants him to do certain things because they're fearful the House Judiciary Committee isn't up to the impeachment task. Jaworski writes back and says, that's just not our business. We're supposed to investigate and bring criminal charges against people in the administration. And Ruth writes back and says, yes, but they're going to mess it up on the Hill, and we have to help them. And so Leon writes back, and he says, you know, I'm not sure this is worth our continuing to write memos. And then he gets to the key paragraph, which of course I'm going to read to you. So this is from his confidential memo to his deputy 6 weeks after this public letter. Now let me address myself to the general tenor of your memorandum, which reflects an attitude I've discussed with you before. The subjective conviction that the president must be reached at all cost. It's also reflected in your references to St. Clair's letter. He was one of Nixon's lawyers. He stated nothing that you should not expect in all fairness. What's of some concern to me are the discussions, plans, and understandings had and reached between staff members prior to any discussion with me. This results in convictions already formed, and frankly, under these circumstances, the meetings are of no help. Now, Leon's memo doesn't have the red. I put the red in there to help you understand the key parts. What he's saying is, you guys are getting together and agreeing on your point of view before you come in to talk to me. So what I'm getting is a uniform phalanx of one point of view and not input. And the meetings are useless because you're having pre-meetings. And then he concludes, the stubborn fact remains we must be alert not to give support to White House charges that have been leveled against the staff. Perhaps it's too late to get objective opinions from others, so I'll have to do the best I can in making decisions for which I will be held responsible. He's saying to his deputy that he can't trust his own staff, that they really are a bunch of zealots. Now, this didn't become public. This is an internal memo, and it was taken by Jaworski. If there was another copy in the archives, it didn't make it into the final files. But Jaworski took his, and I found it, and I put it in my book. So what did they mean that the effort was to reach Nixon at all cost? And what I've uncovered, and it's in the book for the first time, this is what the documents show, is that Watergate prosecutors concluded that Nixon had personally approved the payment of Howard Hunt's blackmail demands. And they secretly assured both the courts and the Congress of their conclusion. Now, the difficulty is they were wrong, but they did it in secret. So we on President Nixon's defense team didn't even know the accusation was being made. But they went into the grand jury, and the documents show this, and they said, we can prove, we've concluded and we can prove, Nixon himself approved the payment. And the grand jury promptly named Nixon as a co-conspirator in the Watergate cover-up indictments. And they secretly assured the staff of the House Judiciary Committee of this same fact. And of course, they promptly recommended Nixon's impeachment. And when you get into it, and it's all in the book, they're doing this in secret so they can't be refuted. But then, after Nixon resigned, his aides come to trial. And while Nixon wasn't on trial by name, he was on trial because the prosecutors wanted to prove their case. They didn't have a chance to bring Nixon to trial. So they announced at the beginning of the trial they're going to prove this. And then their witnesses don't go there. Their own government witnesses won't testify the way they'd hoped. And so at the end of the trial, when they're summarizing it, they just skip it. And you're left with this situation. And this gets complex, and you think this thing through. Nixon resigned because of the smoking gun tape. That's not in my, well, it's not in my book in any detail, but that's why he resigned. Tape is released on August 5th, he resigns on August 8th. But nobody knew of that tape the whole time they were investigating President Nixon. So why? What was the basis for getting the grand jury to act against President Nixon? And it's this representation that Nixon had personally approved the payoff. But Nixon didn't personally approve the payoff. In fact, if Nixon had known that that's what they were saying, he wouldn't have resigned. Because he would have known, I didn't do that. I'm not resigning under that cloud. But nobody knew about this. They didn't have to prove it because the smoking gun came out. So that's Nixon. Now, we're going to go over this slide fairly quickly so I have time to do Q&A. The book's really in two parts. There's what they did to Nixon, and he never came to trial, so it's a different case. And then what they did to the top aides, because they came to trial, and I maintain the documents show they cheated. So the Fifth and Sixth Amendments are about all you have on your side when the government accuses you of criminal activity. You get a lawyer, and you got the Fifth and Sixth Amendments, and the Fifth says no person's life, liberty, or property will be taken without due process of law. And the Sixth addresses itself specifically to your rights in a criminal trial, including being confronted by your accusers. I maintain, and I devote a chapter to each of these things in my book, that the rudiments of due process include a judge who's fair and impartial, nonpartisan prosecutors who are enforcing the law equally. They're not just enforcing it against you, or dusting off old statutes that haven't been enforced since 1934 just to get you. That you get a jury of your peers that's not tainted by adverse pretrial publicity or biased against you politically. And in every federal court, you get an automatic right of appeal to the circuit court. So there's a review to make sure you got a fair deal in the trial below. None of these things existed for the Watergate cover-up trial. And we'll just go through just a couple of them, but the judge may as well have sat at the prosecution table. He was so eager for convictions. The prosecutors, as I've already mentioned, were all ardent Democrats, and they were identifying the people they wanted to get and then deciding what laws they could name against them. The jury, which was within the district, was both tainted and biased. There had been 18 months of unrelenting adverse publicity. And the district is a unique political entity. There's no entity like the district anyplace else in the nation. It consistently returns 80% Democratic majorities, election after election after election. The jury pool from which the jury was chosen consisted mainly, because it's registered voters, of people who didn't like Republicans. And you get a 3-month trial with 5 people, each having a lawyer, each cross-examining someone. And the jury gets so confused by about the 3rd day, they don't know what's going on. And it comes down to, do they like you? And this is a jury pool that's predisposed not to like you. And then you get a right of appeal to the DC Circuit. And what the book discloses, which is just astounding, is that Archibald Cox was so concerned with Judge Sirica's bias in favor of the prosecution that he got worried that he would get reversed on appeal. Judge Sirica was the most reversed judge in the DC Circuit anyway, and mainly on the basis of not respecting defendants' rights. So Cox became very worried that they'd win at trial and it would be reversed on appeal. So he held a secret meeting with the chief judge of the appellate panel, where he explained to the chief judge of the appellate panel in secret how they could stack the deck on appeal and have enough liberal justices willing to hold their nose and uphold Sirica's antics. And that's all detailed in the book. But that at every level where you expect due process, there was no due process. There was flagrant judicial and prosecutorial wrongdoing. So let's just explore a little bit of it. This is one of my favorite slides. Judge Sirica is in the middle, a disgrace to the federal judiciary, He met, the book documents, over a dozen secret meetings with prosecutors and other people interested in the trials, interests adverse to the defendants. 3 of these people are prosecutors, center bottom, Earl Silbert. Earl Silbert is one of the unsung heroes of Watergate. I mean, Earl didn't do anything wrong. Sirica decides that he's inexperienced. So Sirica says in his own book, I like Earl, he's a young lawyer, but I wasn't sure he was up to this trial, the break-in trial. So he takes him aside and tells him how Sirica thinks the trial ought to be conducted. That's not supposed to happen. The judge isn't supposed to lecture the prosecutor in secret and push books in. Here, go read this. Go see what I did when I was a young man. Archibald Cox, who was at about 8 o'clock on the clock dial, we know he met at least 3 times in secret with Judge Sirica. We don't know what was said. But up at the top, Leon Jaworski, who replaced Archibald Cox, we know of at least 4 meetings. We know the date and we know the place, and there are allusions to many others. But we know about the 4 because when he came back to the office, he dictated memos that memorialized the secret agreements they were making. And we have the memos, and conveniently they're reproduced in the appendix of my book. Absolutely unbelievable. You don't know which is more shocking, that they were meeting or that Jaworski was making a record of it. And then the 3 others are people with interests adverse to the defendant. Sam Dash at 10 o'clock. He was chief counsel of the Irvin Committee. They needed witnesses. And what they decided to do, he was a friend of Sirica's. They taught together at Georgetown Law School. So he goes to see him and he says, you know what you could do, Judge? You could throw the book at these defendants and then tell them you'll consider reducing their sentence if they testify before my committee. So in a constitutional inversion, you get the judicial branch conspiring with the legislative branch to thwart the use of real trials. Never before or since in any court in America has a judge said, I'll consider reducing your sentence, not if you cooperate with prosecutors, but if you testify before a legislative hearing. Then at 2 o'clock is Edward Bennett Williams. Edward Bennett Williams, one of the greatest trial lawyers of all time. He was counsel to the Democratic National Committee. They took our break-in badly, and they were suing over the break-in. He was their lawyer. And he was counsel to the Washington Post when Woodward and Bernstein were ripping us a new ear every day. Well, Woodward and Bernstein got a little aggressive during a lull in the reporting, and they decided, well, why don't we go interview grand jurors? You're not supposed to go interview grand jurors, but they did. And one of the grand jurors complained to Earl Silbert, who informed Sirica, and Sirica said, you know, you can't do this. So they sent Edward Bennett Williams in to see the judge on the side to work this out. Now, they'll tell you Sirica's a Republican. He was appointed by President Eisenhower in 1957. That's true. They won't tell you that Edward Bennett Williams was his career mentor, that they were so close that Mr. and Mrs. Williams were godparents of Sirica's daughter, that Sirica wouldn't let Williams practice in front of him because they were so tight. They went to the Redskin football games and all that together all the time. So Williams goes and secretly meets with Sirica and says, you know, it's okay, the grand jurors didn't talk to him, so no harm, no foul. It's just aggressive reporters. They won't do it again. And then Woodward and Bernstein wrote about this in their book, and Williams said, well, you can't put that in the book. My God, it'll make me look sleazy. And they didn't take it out. So he went to their publisher and said, you got to take this out of the book. And the publisher wouldn't do it. So Williams, who knew this could lead to an ethics charge in the bar, didn't talk to Woodward and Bernstein for a full year. And there's 2 books about Edward Bennett Williams that describe this incident. Then, 2 years ago, we learn they were successful in talking to at least one grand juror. Because in a separate book about Ben Bradley, they find in his files a 6-page typewritten memo about the results of this interview with the grand juror. And when they were making the movie, All the President's Men, as distinguished from the book, the producer of the movie in his notes says Bernstein is at another lull and he's going to go back to the grand juror and see what else the grand juror has to say. So you get in this situation where Woodward and Bernstein and the senior staff of the Washington Post, who must have known about all this, have been lying for almost 40 years about interviewing a grand juror. And you don't know whether Edward Bennett Williams knew. You only know he slipped in on the side, blew in the judge's ear, and worked out their problem. And then finally you have Clark Molinoff. You probably don't know Clark. Before Woodward and Bernstein, he was the dean of the Washington Reporters. He was, they didn't use the term investigative reporter. I think they called them muckrakers, but Clark was the best. He had talked his way into being Nixon's ombudsman when Nixon first came to office in 1968 and was talking about the cleanest administration. They all say this, the cleanest administration in history. And Clark went in and said, look, what you need is an ombudsman, a canary in the mine shaft, to alert you to misfeasance in your own administration. And you need somebody like me, and Nixon went for it. But then he tired of Clark's desire to shoot the breeze with him every day. And he froze him out. And the two guys who were responsible for freezing Clark out were Bob Haldeman and John Ehrlichman. So Clark quits in disgust after 10 months, takes over the Washington Bureau of the Des Moines Register, and becomes Nixon's severest critic, and has all the credibility in the world because he worked there. He was also a really good friend of Judge Sirica. And Clark writes in his own book that he was worried that Sirica really wasn't going to be aggressive enough in his presiding over the break-in trial, so he had a series of long, intense conversations with Sirica about the importance of using the trial to discover the truth, not to preside over guilt or innocence, but using the trial to uncover the truth of the break-in. And that's why Sirica gets named Man of the Year by Time magazine for his aggressive conduct of the break-in trial. And Clark is saying, I get credit for doing this. I met with him, my good friend, I met with him a whole series of times, and I convinced him to do this. Well, then Clark wrote a book about it called Game Plan for Disaster. And then he wrote another book, which was a textbook for investigative reporting. And if you put the two together, in his textbook, he says, I knew there was a cover-up, and I knew who was orchestrating the cover-up. They were the guys who froze me out from Nixon. I'm interpolating a little bit. But I couldn't tell anybody because my interview that led me to conclude that was off the record. But I'm willing to bet, we don't have a record of this, that's what he was telling Judge Sirica in secret. Now, you're supposed to get your accuser under oath confronting you in trial. But when the accuser's blowing in the judge's ear bad things about you, you can't cross-examine him, you can't refute it, you're not there. That's why the rules are so clear. Judges can't have ex parte meetings. They just can't do it because it violates the Sixth Amendment. But Judge Sirica was above the law. So that leaves us with my conclusion, and we'll go to questions. I'm innocent me. I'm for truth, justice, and the American way. What we had was a hostile takeover of our government without an election. If no one's held responsible, even 40 years later, then it's likely to happen again. This is not a Democrat or Republican issue. This is a situation where our Constitution and Bill of Rights failed in a time of intense political conflict. So I'm saying, let's get the truth out. I've raised all kinds of red flags, but there's many, many documents that remain sealed. The Irvin Committee and the House Impeachment Committee sealed their records, which is traditional for 50 years. They won't be released till 2024, and nobody who's alive will know anything when they go through them. Let's release them now. Look at what I've uncovered in my book. Let's get the truth out. Let's go take a look at those records. Did the special prosecutor staff the Irvin Committee? Did they staff the House Impeachment Committee? And the record on the latter is absolutely replete that they were fearful the House Judiciary Committee wasn't up to the task. So they took information obtained from the grand jury and from prosecutorial efforts and relayed it in secret to the House Judiciary Committee, a co-equal branch that couldn't get that directly. They were given through the back door. The Senate created the special prosecution staff to have total and unreviewed independence from the Department of Justice. The founding fathers would have told you if you give them that kind of power, it's going to lead to corruption because there's no checks and balances. I'm advocating that the Senate Judiciary Committee today, in light of my disclosures, go take another look at the reasons and rationale for that demand 40 years ago and see what happened. They could investigate a whole lot more easily than I. And I'm saying the court, whose record is just besmirched with wrongdoing, 3 different judges in secret meetings with prosecutors. The court should launch its own investigation and determine what really happened. And they should release the grand jury testimony that led to Nixon being named a co-conspirator. One of the grand jurors told the newspapers that they took a straw vote. You're not supposed to take straw votes. Same grand juror told the newspapers a prosecutor was in the room when they took the straw vote. Prosecutors are not supposed to be in the room when the grand jury votes. We need to see, I maintain the documents all show they're telling the grand jurors Nixon himself approved. But the record's there. We can unseal that and see what they said. Oh, let's get the truth out. Secondly, justice, these convictions of these 3 guys, Mitchell and Haldeman and Ehrlichman, are hopelessly flawed. The due process violations just compound on each other. The challenge to those convictions can only be brought by their descendants. So family members have to come forward. I'm not sure they want to, but for the court to take another look, they've got to come forward and file a petition. And finally, I humbly stand before you, and in light of everything I've disclosed in my book, I tell you, America owes Richard Nixon an apology. The system, Carl Bernstein said when it was all over, the system worked, the American system worked. But you look at my book and you'll see it's precisely the opposite. Nothing worked as it was intended. This was all extra-constitutional. People were cutting corners and cheating because they were so eager to nail Richard Nixon. With that, we go to questions. There are microphones at each side. Please don't throw anything at me. I appreciate your coming. You can walk out if you'd like. No one will say anything. They'll take your names at the top of the stairs. Yes, sir.
Okay. Let's assume for a moment, Mr. Shepard, that everything you said was true. So my question is, you worked in the White House at that time, you followed it through. Do you believe personally that Richard Nixon did nothing to be impeached? And then would you also say that Mitchell, Haldeman, and Ehrlichman did nothing to warrant their conviction, or simply that the process was tainted? And I understand legally that could move it.
Yeah.
But there's really 2 questions. There's the question of law and the question of reality.
Yep.
So that's where I would direct it, and then I want to do a follow-up question.
Absolutely.
So
okay.
First that one.
I know the question's coming. This is the great weasel answer, okay? Let me analogize, if I could, to a sporting event. If you discover later that in this football contest, one side was paying off the referees, you could argue forever but for that, whether one side or the other would have won. Right. But it doesn't matter, because once you've established cheating, you don't inquire further. We don't do it that way. Now, we can't do that here. So right. the first answer is beats the heck out of me. Gotcha. But I will add, remember when I said innocence and exoneration are not on the table? Right. You could say Nixon mishandled stuff without question. There is, I hate to get legal on you, but it's a refuge of scoundrels. In criminal law, it's guilty beyond a reasonable doubt. But in tort law, where you're seeking to recover money for wrongdoing, it really comes down to knew or should have known. I think all 4 could be held liable for knew or should have known. I work on this every night. My wife will tell you it's been 42 years and he won't let go. There's 100 exits off that highway to disaster if they had just done this. Some are nice things if they had just not hired John Dean or Gordon Liddy, if Nixon had pushed a little harder in the beginning, if I believe he came back from Key Biscayne. He demanded the truth. He was told, it's not on tapes, but I think he was told if the path were followed carefully, it might lead to John Mitchell's doorstep. And John Mitchell departed within 2 weeks of the break-in. We thought it was over his wife, Martha. You look inside the record and they're saying, you know, John, it might be a good time to leave because this could get messy. If Nixon had destroyed the tapes. I mean, you could say politicians today have learned that no record is a better record. He could have survived the presidency. Get down to the three people, because I worry about this too. There's nothing that's come out in 40 years that the White House knew of the break-in in advance. Bob Haldeman or John Ehrlichman or the president. I mean, we aren't talking about John Mitchell now. We're talking about these two guys. So you could argue they had nothing to cover up. And what they did, it's a very biased point of view. They trusted John Dean, their lawyer, to go handle the problem. And you know, the re-election committee is kitty-cornered from the White House itself. It's legally and geographically separate. There's a break-in, people are caught. It becomes very clear very soon that the people at the re-election committee are in deep doo-doo. John was sent as the president's lawyer over there to make sure the problem stays over there. Bad as it gets, it won't be the White House. Now, they were worried it was Chuck Colson. He assured them it wasn't. They were greatly relieved, and they said, okay, bottle it up over there. But John Dean knew of Liddy's campaign intelligence plan. He'd recruited him. He's the one that promised him all the money. He's at the two key meetings in Mitchell's office when Liddy describes this unbelievable campaign intelligence plan that involves mugging, bugging, kidnapping, and prostitution. Unbelievable. So when the people get arrested and Liddy says, my team, you know, Dean is at risk of prosecution himself. So I believe that's why he orchestrated the cover-up. Now, every day all over America, lawyers defend guilty clients. I mean, they haven't been found guilty by a jury, but they did wrong, without they themselves committing criminal acts. I think Ehrlichman and Haldeman believed that's what John Dean was doing, that he was trying to keep the problem bottled up over there. Now, he'd come back and he'd meet with them. There's no tapes of his meetings with Ehrlichman and Haldeman. And I know he would say, excuse me, I'm having trouble containing the problem. You know, it's going to get worse before it gets better. But I tell you, as sincerely as I can, he didn't say, did I mention I was rehearsing Jeb Magruder for his perjured grand jury testimony? Did I tell you I was taking prosecutorial information that came to me in my position as counsel and I gave it to defense lawyers? Did I tell you that I destroyed evidence from Howard Hunt's safe that implicated me? Did I tell you that I borrowed $4,000 of campaign funds to pay for my honeymoon? You know, he wasn't saying what he was doing. Even in the famous cancer on the presidency speech of March 21st, when he comes in and tells the president he's in real trouble, John Dean doesn't say what he's been doing. In all of the books, in all of the speeches that John makes, you never hear about what his role was. But you go back through the prosecutor's notes, I mean, particularly the beginning prosecutor, they wouldn't give him immunity because they concluded that he was intimately involved in the break-in. And then there's a point in his book where his lawyer says, the first book, you know, John, they think you're guilty, and you better start talking cover-up to make yourself a witness to go get the other people. And 2 paragraphs later, he says in his own book, this cover-up idea is pretty good. And when you go back through the notes and everything of the prosecutors, they're interviewing John Dean. I think there are 12 telephone calls or extensive meetings with Dean or his lawyer during the month of April. His testimony changes. He says, when he first comes in, I can give you Mitchell and I can give you Magruder. They were at the re-election committee. And then about halfway through, he starts to focus on Ehrlichman and Haldeman. And the notes from the lady who's interviewing these original prosecutors says, before that time, he created the impression that Haldeman was clean and Ehrlichman's involvement was restrained. Now, in the law, we have this case called something v. Maryland. Begins with a B. It'll come to me in the middle of the night. Balky, Blakey, whatever it is. And it requires prosecutors to turn over possibly exculpatory information to defense. They don't do it. I mean, this would have enabled the defense lawyers to cut Dean to ribbons. I mean, you change your story halfway through to accuse these people, but those records never became public until I uncovered them. You had a follow-up.
Yeah. Obviously, you were there.
Oh, let me just finish.
Sure.
If they got a fair trial, and to me, a fair trial is either in Richmond or Baltimore.
No.
Would one or more of them have been acquitted, where everything came out about John Dean, they didn't have a biased judge, they had a fair right of appeal? I don't know. Any jury trial is a roll of the dice. But I tend to believe one or more would have been acquitted. But it's the sports event. We just don't know. You had to follow up.
Yeah, the other thing is you spent time in the Nixon administration and then have been following, as you say, for 42 years. I became a reporter during that time and haven't been following as closely as you. But this is just my theory, and I just want to check it on you, that Richard Nixon is almost like a Shakespearean tragic hero, that many of his own failings were in himself and what he didn't have rather than what he was able to do. If I were to broach that to you, would you agree or disagree with that statement? I hate to use damaged psyche, but I'm going to use it, not the wrong choice. He was elected, he is the president, but some of his insecurities set up his own downfall. Do you think that's true, false, or not, not important?
I worry about these things every night. I have an unpublished op-ed piece, Watergate as Tragedy. And I take Aristotle's definition of tragedy, which is that a prominent individual, not necessarily a pious one, commits some insignificant act, and the reaction of the gods is way out of proportion to that act. And then in Greek tragedy, the entertainment for the audience is to watch the hero, the protagonist, struggle valiantly against this reaction and ultimately fail because the hero must die. And I think that's a fair characterization of Nixon. I think he was the most talented man to become president in our lifetime. I mean, his prowess in foreign affairs is really very, very, very surprising. He was very innovative in his domestic affairs. I've told you that I do these legacy forums, and I've done 35 of them. We go every single thing that he did. But he was flawed. He had taken down Alger Hiss early on. He made a lifelong enemy of the elite Eastern establishment, and they just loathed him. And to some extent, he relished it because he thought he was representing, the people. But we say even paranoids have enemies. He was absolutely paranoid about Ted Kennedy emerging and running against him in 1972. Nixon had barely won in 68, barely won. And he thought the presidency was stolen from him in 1960. And it's on the tapes. He would rant in front of his aides as they were going into the 72 election that Senator Kennedy was skipping the primaries but would emerge at the convention, and they didn't understand the kind of cheating and skullduggery that went on. And he's pushing his staff and pushing the campaign to be more aggressive. I mean, it's almost impossible to defeat an incumbent running for re-election because they got all the stuff on their sides. And they were trying with everything they could to assure his re-election. And again, without supervision, they stepped over the line. There are all these books about Nixon because he's so intriguing. And we have the tapes, and you can farm those tapes forever. I have my Signal that we must be 1 o'clock. It's past 1 o'clock. Thank you for coming. Thank you for not throwing things.